United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call, please. Supervisor Kubicki and Esposito are excused. Citizens' comments. What do you got? It's not total yet? Where's Andy? Where's he? Okay, now we're, all right, we're counted now? All right. State your name for the record, please, and your address. You have 5 minutes. Anthony?
My address is 4223 29th Avenue. I'm the Kenosha County President. I'm also the Alderman for the 10th District. I'm a veteran, served in the United States Army from 1987 to 1991. I'm also the father of a captain in the United States Space Command, which is a branch of the Air Force. The reason I'm here to speak in support of Resolution 63 references Mr. Simmers. We often understand that through just the day-to-day living of our lives, we sometimes encounter obstacles that we have difficulty overcoming on our own. And when those things happen, whether they're in a combat situation, whether they're in a family situation, whether in a business situation, we reach out to others and we ask for help. When I was in the Army, one of the things I was taught is that we will always help one of our brothers in arms, one of our sisters in arms. We will always provide assistance to the almost detriment of our own health, if possible, if necessary. I come to you tonight to talk to you in reference to asking you to support Resolution 63 because we all understand that difficulties, obstacles sometimes show up in our way. But if I understand the minutes from the Finance Committee, there are people willing to help Mr. Timmers, help him overcome his obstacles. I'm asking you tonight, my fellow county board, my fellow elected officials, let's help this gentleman. Let's help this veteran who served our country. Let's serve him now. Thank you.
Any other citizens' comments? Hearing none, citizens' comments are closed. I have a few announcements. Remainder of the second meeting this month will be Wednesday, February 19th. Because of the spring election on February 18th. Thursday, February 20th, the Shalom Center will be having a ribbon cutting ceremony in the new Shalom Center food pantry. I believe on your desk there's a flyer for that. Begins at 10:30, open house is at 11. And the county clerk has one seat opening at the table for the county board supervisors who would like to attend the Susan B. Anthony dinner on Friday, March 6th. See the clerk after the meeting if you're interested. Any supervisor reports? Seeing none?
Supervisor Elverman.
Is it up there? All right. Oh,
I'm looking out for you, my friend.
you're on, Mr. Overman.
Thank you, Mr. Chairman. The first item that I want to mention this evening is the county and Milwaukee and Racine County today met with FEMA officials. We had prepared our engineering and numbers and needs for Kenosha County. Things look to be in the affirmative. It takes a while to get decisions and to get direction from FEMA. but I do believe that our homework that we did on our lakefront project is going to be in our favor. I don't know how many people have been down there. I have one copy, possibly there's a couple others floating around, but I have some pictures here before and after at Kemper. I'll just pass around, and if people want to take a look at them. Other items that we discussed last evening at our Public Works meeting, the Kenosha County Center, we're working on the chillers there. That is on schedule, and the target of completion is April 1st. We also are working on planning and development remodeling at that center, and the move-in is going to be February 14th. In facilities also, Anderson Arts Center grand opening is scheduled. I believe all of you should have gotten an invitation to that. There's going to be a new art exhibit starting at that day, and the opening is February 22nd. Ceremonial courtroom. We are naturally still looking for public and private grant funding, and going to be beginning a benchmarking phase on February 17th. That courtroom will be closed for a short period of time while the benchmarking, which is figuring out how contractors would do the work, is scoped out. Joint service, evidence area renovation. We're assisting joint services with that program, and construction began on January 6th. The District Attorney Juvenile Intake move and remodel. We're creating project drawings and specs at this time. We have naturally many highway projects ongoing. I've reported on most of them. The County Highway W closure, we have bids being open on that February 13th. We're hoping that whoever is successful in that bid begins the project in March. Brookside parking lot, a very big project this year, is scheduled to start in early spring with completion targeted at the end of October. That is the parking lot and safety for entrances and exits there at Brookside. Highway S, that is all on schedule. The Highway F realignment is all on schedule. And KR enhancement, the paving is complete on the section of KR that the state has done, and our planning is on schedule for that. We also have, as usual, many parks projects. The Kemper Center storm damage was the main event that happened in parks this year. Just a couple of the lighter things that are going on. We are happy again to accept a donation from Gruber Law Offices. They donated $6,000 to assist with programming special events, including the movie on the Mound at Petrifying Springs, Picnic in the Park, and a new weekly concert series at Bristol Woods Park. We also set last night the rates for the county golf courses, and they are remaining the same as the previous year. The golf courses also made a decision to begin their staff recruitment early. They've had some great initial results. Parks are doing the same thing. They got it on it here in January and February. It's proving to be fruitful. The golf courses are, Petrifying Springs is full for afternoon leagues. They've booked over 420 weekly league players. Brightondale still has some opening for leagues, but is filling up. And that's it for golf. The division as a whole actually has had a quiet winter. Construction has been able to start on many of these projects, and we're continuing to work to finalize scheduling for all the remaining 2020 projects. That will include the towers, the downtown tower here, the one in Silver Lake Park, the raising of the buildings across the street that we purchased, and we'll be starting master planning processes for the Civic Center and Job Center campuses in February. Thank you.
Thank you. Supervisor Rodriguez?
Thank you. I just want to bring to the attention, I'm sure some of us know, we're about halfway through Restaurant Week here in Kenosha, and it's great to see that many of us have restaurants throughout our districts participating. I want to give a shout out, though, to one of Kenosha's favorites and one that calls the 8th District home. The Spot Drive-In does have a special as well, lunch and dinner, so if we get out of here on time tonight, maybe some of us can swing by there. They got a dinner for two double cheeseburgers, cheese curds, and 2 other homemade root beers for $20. And if you've ever frequented the Spot, that is quite the deal. So I just want to bring attention to that and then thank the different restaurants throughout the community for participating in that. Thank you.
Thank you, Supervisor Rodriguez. Jeff Gentz?
Thank you, Mr. Chairman. Through the chair to Supervisor Alverman. With that courtroom, the whatever, do we have any participants in that working with us? Grants, anything lined up?
At this time, none.
None.
Correct.
Okay. Where are we on the study phase? I mean, are they going to be looking for that next year?
What they're looking right now for that, what this, the benchmarking phase is actually taking a piece of the stained glass that they poured concrete on, taking it out and seeing how you remove that. The reason you do these things, and some of the plaster from the 1920s, you take a piece and figure out how you're going to match that, so that when we do come to serious bidding, that a contractor knows what they're getting into. No one knows at this point, no one has ever removed poured concrete off of stained glass. So we don't want any surprises. We want contractors that have been schooled in the process, and that's what this benchmarking does. It also gives confidence. We do have, when I said we have no one, there's people interested, but a donor, a benefactor, needs to have confidence that the numbers they're hearing will work, and they need to have confidence in the contractors chosen. So there are people that do get involved in these projects, but again, doing our homework to the point of closing that space off for a week so we can get people in there to really scope it is going to be very important.
So is that the survey or the study that we budgeted money for? Or
Correct.
It
Yeah.
is. So what is the timetable for that being done? Why I'm asking is I wonder what is going to come of that for our budget in the upcoming year.
Anything that is occurring right now was budgeted for this year. And there's no money budgeted for construction or anything for next year.
What's the timetable for the study or the survey to be done?
This should be done within the next 2 months.
That answer your question?
Does. And then I'd just like to say that anybody who does want to take a look at joint services with the evidence remodel, it's quite a project. I mean, we had to clear out space, move all these rooms and rooms of evidence, and we have before and after pictures. So if anybody wants to take a look at that, let me know, and I can set that up for you. So thank you very much.
Thank you, Supervisor. Any other supervisor reports? There ain't none?
County Executive Appointments, 30. Thomas Santarelli to serve on the Kenosha County Civil Service Commission.
Refer to Judiciary and Law and Finance.
31. Ellen Kupfer to serve on the Kenosha County Human Services Board.
Refer to Human Services Committee.
Ordinance 12, second reading to required from the Finance and Administration Committee, an ordinance electing to allow under Section 75.35, Section 3 of Wisconsin statutes for post-redemption date repurchase of tax-deeded properties by a former owner. From Finance and Administration Committee, Supervisor Rose, yes. Ron Frederick, yes. O'Day, yes. Gentz, yes. Wamble, yes. Kubicki, yes. Poole, yes.
Supervisor Rose.
On behalf of the committee, I would move the ordinance.
Seconded by Ron Frederick.
Mr. Chairman and members of the board, let me explain to you the new procedure that is advocated in this particular ordinance. First, let me explain that there are two ways of taking property where a taxpayer fails to pay their taxes for a requisite period of time. This ordinance only applies to what one would call in personam taking of property for non-payment of taxes. The other procedure is called in rem, which is essentially a court procedure. The county, as the plaintiff, goes to court against the taxpayer, proves to the court that taxes haven't been paid. The taxpayer might plead its case by saying, well, the reason I didn't do it was because, and advance a reason, and the judge would have the authority under an in rem proceeding to allow payment of taxes, and therefore the taxpayer would be able to complete the transaction by retaining their real estate upon payment of the taxes and costs. The ordinance before you does not apply to that procedure. It's the intent of the county corporation council to use that in rem procedure, I am told, in the future, more often than not. This procedure before you is what I said is called in personam, where the county takes the real estate for non-payment of taxes without going to court, upon giving certain notifications to the taxpayer that the property will be taken by tax deed for failure to pay the real estate taxes, and then the person can come forward and work something out, or has had a good many opportunities to work things out with the county but hasn't done so. So under the procedure that is incorporated into this ordinance, it only applies to homeowners who live in the property, the homestead. It doesn't apply to a developer who has just failed to pay their taxes, or somebody who owns a rental property and they've just failed to pay their taxes. This only applies to the homestead. It only also applies to a former owner who has no mortgage on the property. There's no tax liens, there's no judgments against the property or other special assessments or what we call encumbrances against the property. So it's a pretty narrow group of people that it applies to. Why doesn't it apply to somebody who has a mortgage on the property? Because this procedure of taking of the property wipes out a mortgage, wipes out tax liens, wipes out judgments, so you wouldn't want that taxpayer who has the mortgage to come out better, not only have the mortgage wiped out, but the taxes as well. So it doesn't apply to that situation. It only applies if there's no mortgage, no tax liens, no judgments, or other encumbrances on the property. So under this procedure, what happens? Taxpayer is notified. Taxpayer sends a letter to the Corporation Council. I object to the taking of property, and that objection must be received by the county within 30 days of receiving notice that the county is going to take that property by tax deed. Taxpayer sends in this 30-day notice. It then comes to the county board. Much like the example of Mr. Simmers. Then the board is presented with that objection. What are we going to do? Then it's in our hands to decide, is the reason advanced by the taxpayer sufficient, in our judgment, to allow the repayment of the taxes so the taxpayer can retain the property. So let's assume that we do act in favor of the taxpayer, and after the meeting, the Corporation Council would give notice to the taxpayer, and there would be a 10-day period of time within which the taxpayer would have to react and come in with payment of the taxes and all of the other interest and expenses that might have been incurred as a result thereof. This is a one-time opportunity for the delinquent taxpayer. It's not something that you can do time and time again as a sort of a modus operandi. It's you or your heirs that are able to do this on a one-time basis. So this is what the committee has developed after the discussion that we had a number of meetings ago. This is upon recommendation of the Corporation Counsel, who Mr. Moyer drafted this up. There were some amendments to it, considerable discussion, but the committee has offered this to you this evening on a unanimous vote. Thank you.
Thank you, Terry. Supervisor Nudo?
Thank you. Actually, I have a point of information. It's, I believe, and I've been saying this for the last couple of months now, that this ordinance should have been sent to the legislative committee. I never really got an answer. I've been trying to find out, and I had different answers, to be honest. So for that reason, I'm going to make a motion to send it to the legislative committee.
Motion's been made and seconded. Any discussion on the motion?
I just want to, if I may.
Finish.
Okay, I'm just, basically what I want to say is I'm basing this based on the County Board Rules 2.05 Section G, where it says under the legislative committee, they say all the pending or proposed legislation should go in front of that committee.
Yes?
I believe that
Wait a second. Get a mic going here. Go ahead.
I believe, and I have spoken to Corporation Counsel Joseph Cardamone about this, that it has never been the practice of the county board to send any ordinance change to the legislative committee. What essentially you look at is what the subject matter of the ordinance is. If there's a zoning change of the ordinance, it goes to PDEC. In this case, I believe it's the Finance and Administration Committee that oversees. The clerk deals with the treasurer, property, and they are the correct oversight for this ordinance change. I do not believe it had to go to the legislative committee. I understand that there is some discussion about modifying the language so that it is more clear, but I do not believe that it was required to go to the legislative committee.
Thank you. Supervisor Nordigan?
Yes, thank you, Mr. Chairman. I just need a point of clarification on the current situation, current policy, I guess. So do we give a notice now, and I don't know if I can send it through to Supervisor Rose, the property is going to be taken within 30 days. Do we give a notice out now?
To address the motion to refer to the legislative committee before you get to the substance of the underlying ordinance change.
You did.
The current motion is to refer to the legislative committee.
Go ahead, Terry.
Thank you. Just speaking to the...
Point of order. Someone called the question. Someone called the question.
My question had nothing to do with that, I'm sorry.
I believe it was Supervisor.
Well, Mr. Chairman, technically, there is no calling of the question. You can move the previous question under Robert's Rules of Order. It requires a second and then a vote. Neither of those things were accomplished. So if we want to be technical, the mere calling of the question is not a motion at all. Moving the previous question is, along with a second. That was not done. So point of order, I think, is out of order.
I believe Supervisor Nudo made the motion and Supervisor Decker seconded it, and so now they're debating it, and then I think now that has to be addressed before we get to the underlying merits of the ordinance.
The motion is to refer it to legislative.
Do I still have the floor?
You can. Are you done?
I'll ask a question after.
Yeah. My comments were on the reference here. The chairman referred this to the Finance Committee, And the reason is because our rules say that issues involving taxes, finances, and conveyance of real estate are within the discretion of the Finance Committee, and then we recommend to the board. Some other committee wants to take a look at something. I have no objection here to that. I don't know why that issue wasn't raised at the time of this debate. Months ago. And, you know, we can certainly delay this if that's what you want to do. I don't have any strong opinions one way or the other. And I'm not jealous over the jurisdiction, but it was certainly proper to refer to the Finance Committee, and it was referred without objection. So the next ordinance, or the next proposition before you after this is if you pass this, is the implementation of that with Mr. Zimmer's problem himself. We were going to exercise that discretion and decide you get the property back upon payment of taxes, etc. So if you want to refer this back to the Legislative Committee, it would seem to me that the next ordinance regarding Mr. Simmers should also be adjourned to some subsequent committee when the Legislative Committee reports back that they endorse it or don't.
Thank you. Supervisor Gantz.
Thank you, Mr. Chairman. I will not be supporting the deferral back to the committee for a couple of reasons. Number one, every day that goes by, the gentleman incurs more costs. And we've put this out there. Our committee has met numerous times on this. It was referred from the chair of this committee to finance. At that point, it could have been, referred to both. Also, this is a second reading. Somebody could have jumped on it after the first reading. I don't think it's fair to wait till after the second reading and then postpone, court dates and ring up more charges for the gentleman at this time. We've had countless meetings on this. I'm comfortable with the ordinance that was brought forward, and I will not be supporting that. Thank you.
Thank you. Supervisor Rodriguez.
Thank you, Mr. Chair. Through the chair to Corporation Counsel, is it your opinion then that, I get that we have a common practice here in the county for, I assume decades then, but our rules and procedures kind of contradict our common practice then, it sounds like. So is it your opinion that this needs to be addressed as well?
I believe that Corporation Counsel Cardamone is in the process of working with Supervisor Nudo to address that change in the ordinance.
Okay. I like the ordinance. I think what Finance and Administration did was it kind of answered the concerns that I had from the initial conversation. My concern, though, is I think we've just ceded the point that Corporation Counsel has found that our rules and procedures do not reflect what is common practice in this county, and we have found that out tonight, but we acknowledge that though it's not common practice, it is in the rules, our rules, that pending or proposed legislation go to the Legislative Committee. Now, if we want to change that, we can, and if that's the will of the board, then the board should change it, but right now, that is the rule.
I believe what was discussed significantly at the last Legislative Committee meeting, although I was not there, was that there's a difference of understanding of what Legislative Committee means and how it has been put into practice. I believe it has always been past practice that the Legislative Committee addresses issues of statewide concern, where we are calling on the state legislator to work with the county to address things of that nature. What I believe has been discussed is to clarify that so that there's no longer any confusion. I don't think there's been a concession by Corporation Counsel Cardamone that anything that we are doing is incorrect. I think there's a difference of interpretation, and I think there's been some ongoing discussions about how to clarify that.
Finished.
I guess I'm trying to think of how to word my next part here then. So Chapter 2, County Board Rules of Procedure is part of through the chair to our Corporation Counsel tonight. Chapter 2 is part of all county board, or it's encompassed with other county board ordinances, correct? This is an ordinance in and of itself?
Correct.
And in another word, that's an ordinance is a law?
I think, yes, an ordinance could be municipal law.
Okay. And now when legislation is passed or laws are passed, And it's come to the attention of whether it's an attorney, a layman, whoever, somebody who wrote the legislation, that maybe they did a poor job of writing it, but it can be construed as another thing that, I mean, typically the law is the law. And now, if somebody's practiced it a common way for 100 years, that's okay. But if technically under that law, they can do something a different way, it's still protected and guaranteed by that law. Is that correct?
I think that laws are frequently open to different interpretations, and I think what we're talking about doing is trying to clarify things in the future. But I believe Corporation Counsel Cardamone has had significant conversations about his opinion as to whether or not this had to go to legislative. So I'm not going to criticize prior drafters of the ordinance. I think it's something that we can have ongoing discussions of, but laws and language and wording is always open to different interpretations.
Okay, then on the motion to refer it to legislative, I'll support that. It's my understanding that Mr. Simmers is not in the home. Is that correct? Through the chair, to anybody who can answer that?
We were told that he is in the home. We haven't checked it out personally, but that's what we were informed. There is a raise order on the home from the town of Bristol, but
He's still there.
as we were told, he's in the home, so.
Okay, so Mr. Simmers is violating the raise order based on what I read.
Point of information.
You know, we're not here to defend Mr. Zimmers. That you can vote against
Well,
at
I
the
guess
next
what my
session.
point is, what my point is Mr. Simmers is living in the home right now, regardless of what standing orders are on the home.
Point of
Mi-
information, that's not correct.
Well, whether he is in the home or he's not in the home
It's irrelevant.
is not relevant. That he can defend himself one way or the other on it. I'm not. You
What-
can vote for this ordinance and oppose the return of the property to Mr. Simmers,
well-
because this is a discretionary thing with the board.
Okay.
So I'm not going to get into a discussion or an argument
Point
that
of order,
he's
Mr.
in
Chair.
right
Who
or
has the
wrong.
floor, Mr. Chair?
You were asking me a question.
Terry has the floor
Yeah.
right now.
Okay, it sounded like Supervisor Rose was going on a tangent, not answering the question that I asked him. Or then further moving on.
Provide that point of information if I can be called on.
Hold on. Hold on, Terry. Supervisor Gens, can you answer his question or not?
Yeah, I'm going to
He's got
answer
a-
his question directly. We own the property now, and we have not been served a raise order, so he is not in violation of anything from our point of view.
Oh.
So, just so, it's what I learned.
Yeah.
We have to address the motion to send it back to legislative. They have to address the motion to send it back to legislative committee. Yes, before getting to the substance of it.
You finished, Rodriguez?
No, I'm not. To address Supervisor Gens, the Village of Bristol on, looks like last week, the 27th of January, passed a resolution here ordering the raising of the building located at this address. It reads in part, quote, "The building inspector shall post a placard on the premises containing the following notice. This building may not be used for human habitation, occupancy, or use." So I think it's very clear that,
This doesn't have anything to do with
Right.
with your amendment.
my point is Mr. Simmers is living
We're
in
talking
the...
about the amendment now.
The
You want a
referral.
referral or not?
Correct, and I do. And my point is, Mr. Simmers is living in the home regardless. This can go in front
He's
of...
entitled to it.
This, let me finish, if I may. This will go in front of legislative committee before the next county board meeting, and it can be brought to the county board at the next meeting in 2 weeks from now. So I don't think there's an issue. We've heard from the chairman of finance that he is not opposed one way or the other to this going to legislative, and I think that we should give that committee their chance to see it.
Finished?
Yes.
See no other names? You popped it on there. Okay, Decker?
And I'm asking this because it might sway my decision on referring to committee. So the Village of Bristol posted a raise order, but the county is saying we haven't received it?
They've not received it.
I believe if I may, and Attorney Moyer has been more involved in this, I think we have seen a copy of the raise order. It has not formally been served yet on the county. There was going to be a meeting to discuss it, at which point there would be formal service, but that has not yet occurred, in part because I think everyone is waiting to see what happens.
So posting it on the door is not an official way of the county knowing that it's, I don't know how to say that.
I believe the attorney for the village, and Attorney Moyer might have more firsthand knowledge, has just asked whether or not there would be an acceptance of personal service. They said they would do that at a meeting, and that has not yet occurred.
Okay.
So I think it has not yet been formally served. It's there and issued, but not yet formally served on the county.
Okay, thank you.
Finish? Okay. Nobody else on the board? Did somebody call for a?
Oh, Supervisor Sklinsky.
Okay. Skalinsky.
Thank you, Mr. Chair. And through you to Chairman of the Legislative Committee, my question is, if he could expound what the purpose of referring it to the Legislative Committee, what his intent behind that referral is.
Just like any other ordinance, it's discussed and then it's voted on. But I think the legislative is the committee that has got, so, has to approve or disapprove or whatever, debate on that. And also what I want to, just want to add on that this was not a last minute thing. I've been asking since, I believe since it was a meeting in November, or at least December. I mentioned to John in there right after the finance meeting, and one of the answers was maybe we'll send it both to the legislation and finance, which was fine with me. And I've been talking to Corporation Counsel almost on a weekly basis, and the answers that I got it, yeah, it should be, but well, maybe it's going to do it, and that was it. That's last week. Unfortunately, I was out of town for family problems, and I really could not do it. I even called as of this morning. I said, make sure that I get some good explanation because I'm going to bring it up tonight. I didn't get anything. I never got an answer, so it's still my belief that it should go to legislation.
So just to clarify, Supervisor Noodle, do you have a specific, or are you looking for specific changes, or is it the fact that you would like this ordinance to come through your committee for review?
It's not that I would like, or if I have any changes, that's immaterial. This, for review, it should go to, that's why it goes to committee, to be reviewed and voted on it and discussed. So I might not have anything, say I might, but somebody on my committee might have some questions. So I just want to follow on the rules that we have. I think it's something pretty important. There has been some, not a 100% in favor or against it. So I just want to discuss it at the committee. I think we should have the opportunity to do that.
Thank you. And then through the chair to Corp Counsel. So I'm just trying to make sure that I'm understanding. Is this, let's see, is the interpretation of Corp Counsel correct, or is Supervisor Nudo's interpretation correct? Does this need to go to the Legislative Committee by rule?
I believe it is the opinion of the Corporation Counsel's office that it is not required to go to the Legislative Committee before passing. It is certainly entitled to make that motion, and they could review it if that is what the body decides. We do not believe it is required that it has to go to legislative before passing, because it has been appropriately vetted by the Finance and Administration Committee.
Okay. Thank you very much.
Thank you. Let's see, now we have Ron Frederick. Jeff. Go ahead. Ron?
Am I on?
Yeah.
Okay. The Finance Committee, we referred this by order of this county board back to the resolution that we first tried to get through to give the property back, to develop language so that we could bring it back to the county board and get it approved so that we would have the authority to do what we're trying to do tonight with the property. Now, for 2 months, I guess, I think it goes back to, what's it, November or something? And we've had that at our committee meeting 3 times, and I don't think I've seen Supervisor Nudo there. If I have, he had been there. If he's got some changes that if he doesn't like it, but just the idea that it should go to legislative is not proper, because legislative's job is to recommend legislation to the state, if I remember the Corporation Council, to the state for changes that could benefit Kenosha County. This is already a state ordinance. All we're doing is adopting a state ordinance by state statute. So this resolution to refer back is just a delay. I'm sorry, but that's the way I see it.
Supervisor Frederick, Boyd?
Yeah. Doing an ordinance change, this has been an ongoing discussion. It could probably continue to be an ongoing discussion. But the way Corp Council has stated is, this was referred to Finance Committee, and this is the one people have been working on it. And right now, basically, we're discussing what this should be over a man's, where he's going to live. I think we should get through this and then continue the discussions later on if we're going to do this after we see what we could do for this person. Let's continue it after we take care of this person. Thank you.
Thank you. Supervisor Franco?
Yes, thank you. I'm on Legislative Committee, and frankly, I think until a decision is made by Corp Council, we should go with past precedent. This is a little late in the game to be making a decision to change, where a resolution is referred to. If it's traditionally been referred to finance, it already has gone through. It's a second reading, as was pointed out by Supervisor Gentz. I just think it's bad form to be making a decision on this at this point. Until the language is cleared up, I'm going with past precedent. Thank you.
Thank you. Supervisor Burr?
In September or October, we had an ordinance change on speed limits. I don't know the county road it off the top of my head right now, but I don't expect that an ordinance change on speed limits come forward to the Legislative Committee. We have a committee specifically for that. I don't think that's necessary to come to Legislative Committee. We've had representatives of the state and state senators come to the state, congressmen to the committee, congressmen come to the committee. We've never had Public Works Director, we've never had Parks Director, we've never had Human Services Director come to the committee. So I think bringing it forward now, when we've shown no interest in being involved with other ordinances within the county, I think is irrelevant at this point. I think that there's some stigmas against the individual we're trying to give the house back to right now, and certain people are trying to expand that or extend that time frame for this individual, which I think is not fair to this gentleman. So I will not be supporting this tonight.
Thank you. See no other. Okay. Ready to. We're voting on Supervisor Nudo's motion to send it back to Legislative Committee.
So no, if you don't want it to go back, yes, if you do.
No. Yes, if you want it to go back. No, if you don't. What do they got there? Who are we missing? I can't see it from here. Skulitsky? Motion fails. On the original motion? Yes, if you want it to pass. No, if you don't.
Oh, somebody, yeah, they wanted to discuss.
You want to?
Yeah.
You want it on the original? All right. Just a second, I want to clear the board. Supervisor Nordigan?
Thank you, Mr. Chair. My question, again, I probably chimed in the same time that Supervisor Nudo did. That's why they got crossed up. Currently, we give a 30-day notice on the currently how we run this, correct? And of the property being taken. Is there no chance that the taxpayer during that time currently, how it's being run, can come in and pay the taxes and not get into the takings? So I guess I don't see where the difference is here. That was stated that it'd be a 30-day notice, and then the taxpayer would be able to come in and pay the whatever's due to get it caught up. I don't even know if that's a full amount or just a portion of it, but so I guess I'm a little confused on what the difference is there. Whoever can answer it.
Corporation
all right.
Counsel, either
well,
one.
I defer to Corporation Counsel on that, but as I understand it, number one, all procedures have been complied with, and number two, the taxpayer has been given many opportunities to pay the taxes or set up a payment plan. After the tax deed is
Right.
issued, theoretically, there's no opportunity. That's how we got into this discussion about changing the procedure so that the taxpayer could pay the taxes if the board so desired, and we would convey it back to the taxpayer.
Well, maybe
so the
I
answer is there is a big difference between the current proposal and what we do.
And maybe I misunderstood this. I thought you'd said that they'll get a notice that, you know, they have 30 days, they're going to be taking the home, and it just sounded like at that point there's nothing you could do. But now, currently, but now you're saying that within that 30 days, you'd be able to come in and get caught up or whatever.
Well, no, the way the ordinance proposed before you is that there are 30 days to object to the taking by tax deed. Taxpayer sends a letter, I object. That letter comes to the board. We say, we'll give you an opportunity to pay up, make good.
Okay.
And then the board the Corporation Counsel will notify under the ordinance. Taxpayer then has 10 days to pay it up. If they don't pay within 10 days, it's done.
Okay. Thank you.
I don't know if the Corporation Counsel has anything to add to that.
If I may,
Go ahead, Andrew.
Attorney John Moyer is here, and maybe he can speak to your question about the difference between when the tax deed is taken and then what happens with this ordinance.
The tax deed is recorded. Normally, after the tax deed is recorded to the county, there's no going back, short of an ordinance like this. So after the tax deed is recorded to the county and the county owns it, that's when the 30 days would start to allow this person to object to that and be heard by this body as to whether or not the ordinance remedy should be offered to them and that they could, the rescission of the tax deed. So it's different from, you know, any other time limit during the process of taking the tax deed. This is post-taking.
I thought I heard them say it was they sent out a notice and within 30 days of the taking. So it's after the taking that this all starts kicking in.
Right, that's when the 30 days to make an objection in writing to the county that they want to be heard on the issue of whether this ordinance ought to be made operational and that they should have the remedy of rescission of the tax deed.
Thank you.
You're welcome.
And one more thing.
Okay.
Currently, it seems like we have a fair and equitable way of coming in. If you had any issues, work it out with us and all that. I don't see why a change is needed to be made based on a bad policy. It doesn't seem to be a bad policy. So I for one, can't support the policy going forward, how it's changed. Thank you.
Yeah, thank you. I believe what we have in place now is fair enough. And also, I believe the Supervisor Rose said that there's some discussion or something that we're going to start trying to use in REM a lot more than what we are now. So if this thing was worth the time to talk about it, it's the fact that finally, maybe we're going to start to use it in REM versus with the tax deed, where it's going to be a lot more beneficial for the county, and I hope we're going to use that. And if we do, really, this ordinance doesn't really mean anything. But I'm going to vote against it.
Thank you, Mr. Chair. Through the chair to whoever can answer this, in the ordinance, letter I reads, an individual or his or her heirs may exercise this option only once. Any subsequent action under this section by said individual or his heirs shall be denied. Does this mean then if somebody's father is delinquent on the taxes, they go through this process, they get the property back, it then transfers to an heir, the heir does the same thing, that they can't do it either? Like it's been denied? Or is it, the father gets to do it once and the child or a different heir gets to do it again? To whoever can answer that.
It's one time.
So essentially, one time per family.
Cumulatively.
Per family, though?
Yes.
Okay, so this wouldn't stop somebody, the property's regained control by the original owner, they sell the property, the new owner would then have an opportunity to do the same thing, though, correct? It's a different owner?
A completely different owner, not an heir, not a family member?
Correct.
Sure. Yes. I mean, that can happen now. We don't need an ordinance change to deal with that. That's not the issue.
My concern with going through and changing this was that we were going to have a lot of repeat and referral customers, so to say. This ordinance seems to address that. My concern, though, is, and to go off what Supervisor Berg stated, I, for one, don't want to see this individual without a home. He's done a lot for his community. I think we need to take care of him as well. My concern, though, is this raise order. So though it might not have been formally served upon Kenosha County, okay.
Finish. You got the floor.
My concern is we're changing this for somebody that brought this to our attention. I applaud Mr. Summers for doing that. Our constituents throughout the county should bring to the attention the county board issues and changes that need to occur. I guess I won't dig deeper into this particular situation, but I think nonetheless, this person is going to be without a home, and we do have questions that we need to answer now. So I'll support the ordinance change tonight. I'm excited and happy to see that Finance did take care of the repeat referral issue that I thought would arise from this. That's all I've got to say on this issue.
Nobody else on the board? Want a roll call vote? Yes if you approve, no if you don't. I can't see that board at all. I can see this, I can see this one. Motion passes. Who's left?
No.
All right. Next resolution.
Resolution 63 from the Finance Administration Committee, a resolution authorizing the conveyance of property located at 11713 212th Avenue, Bristol, Wisconsin, to John Simmers, parcel 37-4-121-312-0272. From the Finance Administration Committee, Rose, yes. Ron Frederick, yes. O'Day, yes. Gentz, yes. Wamble, yes. Kubicki, excused. Poole, yes.
Supervisor Rose,
I move the resolution.
seconded by Jeff Gentz.
Members of the board, this is the implementation of the ordinance that you just passed. The whole issue came to the board because Mr. Simmers complained that he wanted to make good and pay up all of his taxes and expenses and get back his property. And under the current state of the law, before the prior adoption of the ordinance, it was not possible. So the ordinance was drafted to apply to a Simmers type situation. There is another individual who I understand is attempting to also obtain his property back, and that issue will probably come to the board as well. And there may be a few issues, other taxpayers in the future. I think it is correctly stated that this probably isn't going to happen very often, but the ordinance was adopted to address the Simmers issue within the context of a law that we have adopted, namely the ordinance previously adopted by this board.
Thank you. I'm going to clear the board and start over here just in case there's anybody. Now, anybody wants to talk about the issue now? Supervisor Nudo.
I just have a question, maybe somebody can answer that. So basically, this resolution is due to the ordinance that we passed before, correct?
Yeah.
Which, if I remember correct, I don't have it in front of me, which it was a time limit, had to be done within 30 days, which now really it takes out of the 30 days because the tax deed was taken on the 26th of August. So really, we tried to do a resolution or an ordinance for a specific person, but at the same talking now, this resolution is not within the means of the ordinance that we just passed. So there is another case where we do things, but we really then want to change the meaning of what we're doing. So, I mean, can anybody answer on that? Am I seeing this the right way, wrong? Because he says within 30 days, so the 30 days are gone.
Attorney John Moyer has been the one involved with drafting this ordinance and can speak to how it applies to Mr. Simmers.
It is available to Mr. Simmers for the reason that the ordinance allows that he make the payment within 10 county business days of the county board decision to offer the remedy. So if the county board offers the remedy and passes this resolution, that allows Mr. Simmers 10 business days, 10 county business days to pay the amount of the taxes, the interest and penalties, and the costs, which have been calculated by the clerk of the county, somewhere near $16,000. He has that remedy available to him. The 30 days is that the individual has to notify the clerk in writing within 30 days of the recording of the tax deed in order to be considered for this remedy. So that doesn't put Mr. Simmers out of eligibility for the remedy because he's made the objection very soon after the tax deed was taken. And again, if this board passes the resolution allowing the remedy to apply to him, he will then have 10 county business days in which to redeem the property by payment in accordance with the ordinance.
Okay, and on that, when is the date that he put in for the objection? Because the tax deed was taken on, I believe, August 26th or something like that. When was the objection given in writing to the county?
I believe Mr. Simmers objected
shortly after the tax deed was recorded on the 26th. I cannot give you a specific date, but he made it very clear that he was objecting to the taking, and he was looking, I think he contacted Supervisor Uhas at some point as well to figure out how he was going to get that issue heard. I'm afraid I can't give you a specific date that he notified the county, but I believe it was done very shortly after the taking and the recording of the deed. I know that the clerk's office dealt with Mr. Simmers as well early on.
Okay, I'm confused for two things, okay? One is when we were talking, one of the reasons was that nobody could get all to talk to him. So now we're saying that we had the notice within the 30 days, and I believe the notice should have been in writing. That's what it calls in the ordinance. So if that was in writing, we should have some piece of paper showing the date that it was done. So do we have that anywhere? I mean, if we don't have it now, can that be provided to us to see it?
The other issue, the other thing about this issue is I believe the committee also basically indicated they would grandfather in both Mr. Prill and Mr. Simmers because they made their objections known very shortly after the tax deeds were taken, and this ordinance didn't exist. The time limits didn't exist at the time they made the objections, and that was my understanding of the committee's intent.
But again, it's a little bit different than what the ordinance that was just passed and what we have in this.
Are you done, Supervisor Newell?
No, I was just saying, I said, to me, it's different from the ordinance that we just passed with this resolution that we have in front of us now. Thank you.
You done now? Yeah. Thank you. Supervisor Decker?
I have questions about the raise order, because I'm not familiar with raise orders. When a raise order is given, because it was given by the town of Bristol, or village of Bristol, are people allowed to live in a house afterward?
Mr. Moyer?
Chapter 66 of the statutes discusses what can be done when a raise order is issued. I must confess, because the county doesn't issue raise orders, to not being really familiar with the process exactly. But I do know that there are remedies in terms of objections that can be made by someone once that service is provided, that the building is to be raised. They can, for example, file for a restraining order to stop that if they do so within 30 days of the formal service of the raise order. So there are certain remedies available that it seems to me might allow them to continue residing in the property even while that order exists. But I believe in this case there was no formal service at this point made either to the county or Mr. Simmers. And I honestly personally don't know whether he is living in the building or not. I do know that my understanding is that the village of Bristol and Administrator Kirkman communicated with him, and among the things that Mr. Simmers, and I wish he was here because he could answer these questions, but I think he had talked about a neighbor from whom he could rent. I know that the veterans group was involved with offering him possible housing arrangements if he had to vacate for this reason. I'm not certain whether he's living there or not. My last known information is that he was still living in the home.
Another question: when you have a raise order, can it be reversed that, for example, I believe Mr. Simmers wants to fix up the house to live in it. Can that be done after a raise order is issued or not? I don't know these.
Again, looking at chapter 66, I do believe that there can be negotiations and discussions between the municipality and the owner. I don't know whether Village of Bristol is willing to do that or not, and I don't know that because I know there's mold issues which may not be something they're willing to negotiate on. I do believe that there is a possibility that there can be some give and take between the municipality and the owner of the home
and working together as to whether or not there's a rehabilitation possible, a remodel, a partial raise. I think that that's ultimately going to be between the resident/owner and the municipality.
Okay, thank you. And I'm asking this because we're the owner right now, and I've seen pictures of the house, and it's not safe for him to live there, in my opinion. And as you know, we could be sued if he's living there and injures himself. So I'm just, thank you.
Thank you. Supervisor Rodriguez?
Mr. Chair, the ordinance is passed. Like I said, I really do feel for the gentleman. I'm going to vote in favor of it tonight to give this man his property back. I do have my concerns. I share the concerns of Supervisor Decker with possible litigation. And I, like Corporation Counsel stated, I wish he was here so he could answer some of our questions tonight. I wish him all the best. I'd hate to see him pay to get his property back here, the sum $16,000, and then let's use a round number of $10,000 possibly to raise the home. You know, be forced to spend the money to then raise a home and then have a lot. And he went through all of this to just have a lot. But I mean, if this is his wishes, you know, like I said, I wish the best. I'll be supporting him tonight. But I think it's important that this body and Mr. Simmers understand as well that it's not quite as simple, or it doesn't look just quite as simple as him getting his property back. He lives how he's been living, and that's the end of it. This seems like there's quite a long road ahead of him here. So that's all.
Supervisor Nordigan?
Thank you, Mr. Chairman. Again, it has to do with the raise order, that the Kenosha County is a current owner, and I don't know that, again, we don't even know that's been served yet. We just know it's out there, correct? So when this reverts back, as I'm assuming it's going to, because I too will support this now that it's part of our policy, I'll support sending it back to. My concern is now a new raise order comes out, Kenosha's out of it, bang, here you go, and you got to destroy the property. It is a local thing. It's going to be up to the village and the owner of any building, I guess. But are we setting him up to fail? That's my concern. However, it's something that I believe we now have to support going forward. Thank you.
Thank you. Supervisor Berg?
I've heard a lot of questions tonight. Some of them to be answered are, why is Mr. Simmers not here? He's currently at home. He's got the flu right now. That's why he did not show up. He's been under a lot of stress. His father died last week. So as you saw him up here stutter through many of his conversations up here and downstairs, that's put a lot more stress on him this week. Part of the discussion that I've had with him and Colonel Hashimoto is they do have a contractor, a buddy of theirs, that's come out and taken a look at it. With the raise order comes the taking away of the foundation. They are trying to work it with the contractor so that the entire property isn't raised. They want to be able to take down 3 walls. One of the walls is what was put on as an addition. Believe it or not, as small as the house is, there was an addition at one point. But they still want to save the foundation of the property, which costs a lot of money to have done after, to begin with. I think the question that was asked by Supervisor Nordigan is, are we setting them up to fail? Colonel Hashimoto is a 37-year veteran of the Marines. He's a full-bird colonel. He's got a lot of called organizing of missions overseas and combat that fixing a house is I think going to be minuscule, and I think he's got a lot of veteran buddies, veteran friends that are going to help set him up for success. As was mentioned earlier, he has already gotten financial assistance from the 82nd Airborne, Southeastern Wisconsin chapter. He's gotten a lot of changes in his financial situation due to him having to pay for his medications in the past, and now because of his age, he's able to have a grant to cover those costs, and he now has now has income to be able to take care of the taxes. Another question, or another point I wanted to make was to Director of Finance. What is the owed amount on the taxes and the fees?
Yes, it is $15,966.
Okay, so we approve this today. He comes in tomorrow and he pays that almost $16,000. If we don't approve it, we're out that $16,000 because of fees that we're not going to get anymore, and because we've already paid that 16 or whatever that tax property or property tax value is to Bristol. So we're going to be out that anyway then. So it's almost financially beneficial to us to be able to get that $16,000 tomorrow.
It does satisfy what we have into the property, yes.
So to me, that's fiscally responsible.
Pay to raise.
And I'll be supporting this tonight.
That's it?
Yes.
Thank you. Seeing no other names on the board? Roll call. Yes if you support it, no if you don't. Motion passes.
Communications 35 from the Finance and Administration Committee, a resolution authorizing the conveyance of property located at 307 Highway Z, Twin Lakes, Wisconsin, to John Prill, parcel 85-4-119-212-1020.
Refer to Finance.
36, communication from the Judiciary and Law Enforcement Committee regarding Resolution 2020 Wisconsin DOJ NCS-X Implementation Grant.
Refer to Judiciary and Law.
Communication 37 from Legislative Committee, a resolution calling on the state legislature to pass 2019 Assembly Bill 491 and 2019 Senate Bill 442 to prohibit vaping wherever smoking is prohibited.
Refer to Legislative Committee.
Communication 38 from Legislative Committee, a resolution to conduct countywide advisory referendum on the creation of a nonpartisan procedure for the preparation of legislative and congressional redistricting plans and maps.
Refer to Legislative Committee.
Summons and complaint number 19, the estate of Vickery Frederick versus Brookside Care Center.
Refer to Corporation Council.
The approval of the January 21st, 2020 minutes by Supervisor Nudo.
Moved and seconded. All those in favor? Aye, carried. Thank you. We are adjourned. Vote on it. All those in favor? Aye. All right. Yeah.